Hi, I'm Tim Larson. I'm a partner here at Larson & Brown, and I'm going to be explaining to you an article from our trust documents that is very similar for everyone, and this article is Article 5. It deals with the administration of the trust upon the death of a grantor. The grantor is the person who's created the trust. If it's a married couple, it's both spouses. If you are a single person, it's still going to be Article 5 of your trust, and the provisions will be very similar. For the joint trust, it says after one of us or after the first of us dies, and it goes on to explain the administration of the trust. This is a provision that authorizes the trustee to have the authority to take care of what I like to call all of the loose ends. All the things that a person who's in charge may need to take care of. It's referenced as an administrative trust. This is the part of the trust that authorizes the trustee to take care of things like paying bills that need to be paid, referenced as expenses, to file a final tax return, an income tax return, and to, in general, deal with all the things that need to be cleaned up, taken care of, pay the bills, dispose of property that needs to be disposed of, gather property that needs to be gathered together. And there's much more to this, so I'm going to go ahead and explain some of it to you. Kansas has a law that says life insurance death benefits can be protected from creditors. So there's a provision in here that tells the trustee to do so. And then there's much in here that references the possibility of paying death taxes, which we commonly refer to as estate tax. Kansas no longer has an inheritance tax or an estate tax. Inheritance tax was repealed in Kansas in 1997, and Kansas then had an estate tax that remained in place until the end of 2009, and presently there is no death-related tax on the state level in Kansas. The federal estate tax has been changed drastically over a number of years, but most recently in 2017, but before that in 2013, when several things were changed, and one of those was to leave in place the threshold before taxes at that time, which was $5 million, and then that stepped up over a number of years until it was just about $5.5 million at the end of 2017, and then it was doubled for an 8-year period that will continue through the end of 2025. And so presently in 2019, the threshold before there's any federal estate tax due is $11,400,000. That only affects 1/4 of 1% of the total population, so estate tax has gone away as being a primary focus of estate planning. And even though it's up at that high level, it'll come back to about $6 million at the end of 2025, but that still doesn't affect very many people. And so the focus now has changed almost 180 degrees from estate tax to other issues such as asset protection for beneficiaries, making sure that we can plan to avoid capital gain by getting a complete step up in basis. And the whole tax structure has changed very significantly. But we do still have provisions in the document to deal with the payment of those death taxes. But until it changes, it's impossible to say that what the law is now is permanent. It's permanent until they change it again. But right now, it's just unusual or unlikely for most people to have to deal with an estate tax that has such a high threshold before there's a requirement to file. So there are provisions in your trust that will deal with if there is such a tax, which could happen after a major election, a changing of the winds in Washington. But you'll see throughout Article 5 references to making tax elections and dealing with estate tax. And of course, the tax elections apply to income tax as well. And in a simple sense, it's just the authority for whoever's serving as trustee to be able to make decisions that will allow the least amount of tax to be paid. In Article 5, there's also reference to probate and coordinating things with probate and with the executor of the probate estate, if there is one. Remember, we have done a will for you that we call a pour-over will, and that will is like a spare tire. That's the best metaphor I can think of to use. When you have a vehicle, you don't want to drive one without a spare tire. But if you were asked, when do you want to use the spare tire, the answer to the question is really never. And I think of the pour-over will the same way. If we can fully fund the trust and make sure that assets are either titled in the trust or will transfer to the trust at death, or are established in another transfer at death manner so that we avoid probate, unless you have something that's just in your name alone, or you're entitled to something at your death that's just to you individually, we shouldn't need to use the will. And probate is caused by having assets that are just simply in the name of the person who died, with no other way recognized under the law to take possession or title without having to go and get a court order through one of the various probate procedures. So we have reference in here to, if there's a need to utilize probate, to coordinate that with the trust, and typically the executor or executors would be the same as your successor trustee or trustees, and that will, there's enough language in here to make sure that those things can be coordinated. There's reference to other types of taxes, such as generation skipping tax. We have the appropriate language in here so that really it's not something you ever need to worry about. You have a very large generation skipping tax exemption that can be allocated, and many times under the Internal Revenue Code, it's deemed to be allocated to cover a generation skip, but it's the same amount as your federal estate tax exclusion, which is that $11,400,000 figure right now. So the law was passed to prohibit the really wealthy families in the country from doing that type of planning to avoid paying estate tax, and so it is a very high threshold. For most people, it's not an issue. The last item in Article 5 is a provision that relates to what we call portability. For married couples, this is what it relates to, is at the death of the first spouse, we now have an option to go ahead and file a Form 706, which is a federal estate tax return, and to do that, not because there will be any tax due, but solely because we want to preserve the unused credit or exclusion that belongs to the estate of the deceased spouse, and it's portable or ported to the surviving spouse so that it is added to whatever credit or exemption they have at the time of their death. And it's discretionary, but many times if we have a feeling that Congress may reduce that threshold back at some point for the surviving spouse, for the cost of preparing a federal estate tax return and electing to have the full amount of the unused exclusion transferred over, made portable to the surviving spouse, we can make sure that the surviving spouse's estate also stays in a zero tax position. As I said, that's Article 5. It deals with the authority for the trustee to take care of administrative matters with the trust. And if you have questions, you can always contact us here at Larson & Brown at 316-729-0100. You can go to our website, which is basically larsonbrown.law.